happens is, if anything happens to that primary trustee, if they die, if they refuse to act, if they get frisky and want to charge you a big fat fee, you can't get rid of them, except in my trust, because we have a successor trustee. So if one of your trustees doesn't want to act, or you can't find them, or whatever might happen, in your system, there's a termination of trustee form. In your system, there's a resignation of trustee form. So what happens is, you can get rid of your trustee that fast. Now what we're going to create here, though, is a document on public record that already has a successor trustee in it. So that, if anything happens, we instantly kill off our primary trustee. The secondary trustee, the successor trustee, automatically, by operation of law, is already in place. How many of you love that plan? No heavy lifting and no need to re-record the trust document, because you already have a backup plan.
How do you get rid of the initial the public trustee?
Well, let's talk about strategy, Keith, for just a second. Strategically, you could have a trustee in another state. Now, Stu, isn't this correct, that if there's a lawsuit filed, they have to serve the person? Before anything happens with the lawsuit, they have to serve the person. If the person is not here, could that make it tough? Like, really tough? Well, how about Alaska? Well, where they have to get on a plane and fly over. It's really interesting. One of our, anyway, we have a coaching group, my Platinum Mastermind group, and many of them serve as trustees for each other. And one of our most popular trustees lives in Alaska. So you can just imagine strategically that primary trustee could actually be hard to get. Now watch this one. Our successor trustee could be your next door neighbor. So then you terminate your primary trustee, and your successor trustee closes the transaction. Are you with me now? So when you get ready to sell, it could be somebody very easy to get instead of hard to get, because of that magic of having the successor trustee. Good plan? Yes, sir.
How do you terminate it?
Can a trustee be another trust?
No, we don't want to do that. We need a human being, because you see, a trust cannot pass the asset on to the rightful living heirs. We need a human being in the mix. And to answer your question, Keith, there is a document in here called Termination of Trustee. And so you'll just use that whenever you want to terminate your trustee.
As a beneficiary,
The beneficiary retains total control over the trustee. The trustee cannot do anything until told to do so by the beneficiary. Is that a good thing?
Yeah.
They can't do anything. So the power of direction is retained by the beneficiary. The beneficiary tells the trustee what to do. The trustee cannot act on their own accord, or they're in violation of the contract and in violation of the law.
Doesn't that make you vulnerable, though? If somebody wants to sue the beneficiary, don't have protection, or the beneficiary having access to the
Trustee, it's not published anywhere. The name of the beneficiary is not published on public record. It's published inside the trust, but that's not published for the public domain. Not even Facebook. Unless, listen to me, unless you run your mouth, nobody knows. If you can keep your mouth shut, even with your own trustee. Now, what if your beneficiary of your land trust is actually another trust? Then it's the successor trust, the trustee of that trust that tells this trustee what to do. If this trustee doesn't know who the beneficiary of that trust is, they don't know. Is that correct?
Correct.
And if they don't know, I don't care how many depositions and interrogatories you have, they don't know. So that's a lesson just to keep your mouth shut. The next thing is the trustee's true address. Now, essentially what we're creating here is a roadmap to your trust. A roadmap. And all the details of the trust in terms of who the players are going to be right on this one sheet of paper. Once you fill this out, you've got everything you need to complete your trust. So we need the trustee's true address. Why? Because you might die. Sooner or later, that's probably going to happen. So when that happens, then you're going to get the benefit of, or excuse me, your family will come to the file folder and find this information, and it will tell them exactly who to contact. The trustee's true address, the trustee's phone number, the date of the trust creation, everything is right there on that one document. Now, of course, the rest of your trust documents will be there too, but they just need to know how to contact the trustee in order to sell the property. Other than that, it can stay in the trust. At your death, that trust doesn't die because of the nature of this trust. Now, there are other trusts that do die at the death of the beneficiary, not this one. The way this has been designed is this trust lives on after the death of the primary beneficiary, so that the secondary or successor beneficiary could just leave it there. Just leave it in that trust, leave the trustee in place, and do absolutely nothing except use the property or receive the income off the property. Is that a good thing?
Yeah.
Oh, that's a beautiful thing. So let's continue on with our creation information worksheet. All right, so we talked about naming strategies earlier. Now, those of you who have already thought of a name, go ahead and put the name in there. The Refugee Care Trust, the Stevenson Road Preservation Trust. Wouldn't that be a nice name? Somebody looks at that on public record, they think, oh, this is like one of those do-gooder organizations. In fact, you're actually going to have the word land trust in there. Oh, it's one of those land trusts. Now, there are land trusts out there that are usually huge. They own thousands of acres of land. And guess what? They put it in a trust. They put it in a land trust. And so when people hear the term land trust, they could think it's one of those non-profit organizations that holds title to property in a land trust. Is that a good thing? Ooh, yeah. All right. So obviously the why is the naming strategy, is the reason that we want to adopt whatever that item is. The next is the primary beneficiary or beneficiary shall be. Now here, you're going to determine exactly who's going to get what. So if you already own it, you can name yourself as the primary beneficiary. If your LLC already owns it and you've already filed tax returns to that effect, then it's a good idea to keep the LLC as the beneficiary. Why? Because there's no taxable event in the transfer of the property from the LLC to the trust as long as you keep the LLC as the beneficiary. If you don't keep the LLC as the beneficiary, then there's actually the possibility of a taxable event. Now, What we're going to do as part of these trusts, and how many of you is your first trust going to be actually transferring a property you already own? Okay? So, in doing so, we want to avoid any kind of taxation on it. Is that right? Yeah, we don't want to. We want to retain our homestead exemption. We want to retain our rights to the property, our Prop 13 values, all that good stuff, right? So, you're going to notify the tax office with a form that is filed with the deed. Okay, so that every deed that's filed, they also require you to fill out a form because they want to figure out what kind of transfer this is for tax purposes. If it's a transfer from a seller to a buyer, that's two different families, they're going to get a tax out of that. They're going to get a transfer tax out of that. But when it's a transfer from yourself to yourself, from yourself to your trust, then there's no taxable event. So we're going to put on the form from the county and the state, we're going to put on that document, gift. Now they may have some check boxes and you just check off gift to trust or transfer to trust or family trust, whatever they may have on there that distinguishes you not paying for this transfer. That's the one we're going to check off. It does vary from county to county, but it shouldn't, but it should. It does from time to time. So my point is, you're just keep the word gift in mind, that you are gifting it from you to your trust, and therefore there is no taxable event. Now, if your LLC is gifting it from itself to the trust, and it is remaining the beneficiary, then that's the same thing. There is no taxable event when an LLC is transferring out of LLC into trust. However, the LLC is remaining as the beneficiary. There is no taxable event with that. Is that a good thing? Yes. Yes, sir.
Does this preempt inheritance taxes as well?
No. That's a separate calculation. So inheritance tax is going to be based on, although you're going to like this, I teach you how to double the inheritance tax deduction. Is that a good thing? Now currently, the inheritance tax deduction is $5,286,000, I think, something like that. So if you got more than $5 million, then and you're married, then we could do an AB trust, and you can both qualify for the $5,200,000. So that now boosts it up to $10,400,000. And if you got more than that, talk to me. I need to borrow some money. No, talk to me, because there are other trusts once you exceed that limit that can help with the inheritance tax issue. Oh my goodness, it's a beautiful thing. All right, let me stay on point, and if I have enough time, I'll answer more questions. Okay. All right, so the primary beneficiary or beneficiaries shall be, now if it's you, then you're going to make yourself the primary beneficiary. If currently it's owned by an LLC and the LLC has already filed a tax return, then we're going to have to make the LLC the beneficiary of the trust, okay? The percentage of beneficial shares shall go to. That is your decision. Remember, this is your stuff. So I'm not going to tell you who the beneficiary is or how much they should get. That's completely your decision. You could make yourself the 100% primary beneficiary of this trust. You could make your spouse the 100% successor beneficiary of this trust. And then if you got another property, you can make your spouse the 100% primary beneficiary, make yourself the 100% successor beneficiary. Now, in a community property state where they're going to split everything anyway, if you've already split everything anyway, is that a good thing?
Yeah.
Does that kind of solve the problem?
But what happens if you get a judgment against you and you are with your wife and all your property? How do you...
But Roberto,
You don't own it.
here's the quiz. Do you own anything?
Well, if you don't know, but is there something that the court can do against your trust? Can they really drill a hole through your trust?
What they can do is attach your avails and proceeds. You don't own the property, right? Everybody got to get that through your mind. You're going to have to hear me say that 15 times before you get it. Paradigm what? You don't own it. It's not yours. You don't own it. The trust owns it. You merely own an interest in the leftovers, the renderings, the money which may come from the trust. Somebody gets a judgment against you and they say, we want your avails and proceeds. Then you tell the trustee to spend all the money. You just tell the trustee, hey, I think we need a new roof today. I think we need some new plumbing. Now there's this thing called a charging order, which gets really interesting. A charging order now means that whomever has the judgment now got what they didn't get. They got an interest in the avails and proceeds which didn't come. So they have to pay taxes on money they didn't get. That's what causes them to get really interested in settlement. Because it's like, I didn't expect that to happen.
But if,
Yeah.
excuse me, but if you're not, if you name another trust as the beneficiary and it's not public record, then it's going to be very hard for anyone to be able to collect anything.
Ian, you put your finger right on it. That's exactly right. So if you set up remember the paranoia scale?
Yeah.
So if you set it up that the